Pretty good, how are you?
Pretty good, sir. Check in with Miss Patty.
Sir?
Check in with Miss Patty already. She had your meeting.
Yes, sir. I'll be doing a lot better. I can get this leg operated on.
What you got?
Osteosarcoma.
Shit, look at that.
It's a bone, like a bone cancer. Right there on the front. And I fractured it like 3 or 4 years ago, and it never really healed back.
Any cause of it?
Apparently it was a fracture and it was a piece of tissue or muscle or something got between the edge of it. It caused that bone to die out.
No cause of it.
Yeah, it doesn't have to, but it did in my case.
What do you do?
I just finished radiation. I did like 5 days a week for 25. Yeah, they put one right down here, one right here, right in the center of them. And there's an extra.
You know what happened to you? 10 years ago, I had prostate cancer.
I don't know, I can hear y'all.
Oh, thank you.
You might say anything ugly about the party.
Not you, you know,
Okay.
that's a couple of times. Yeah.
All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Sky Cooper. I have a note that Ms. Cooper called the court this morning indicating that she was having car issues, so we'll recall her case.
Pardon me.
Darian Dotson. Andrew Holden. Andrew Wayne Holden. Adriana Jacobs. And just for the record, Ashley Autumn Old, CR 2302, Saints Court hearing. Court has signed a order of dismissal on her case for successful completion of community supervision. Nathaniel Potter.
President.
Crystal Getz.
Here.
Is it Getz? Is that how you say that? Thomas Norman. Jennifer Rollins. Andrew Francisco Melton, CR 2478. Mr. Crawford filed a motion for continuance to which the court granted. Matter's been reset to Thursday of this week. Mr. Crawford's going to be in trial continuing on Thursday, then we're going to reset that to August 13th. Nevertheless, Mr. Melton did appear this morning as instructed by the court, signed his notice of appearance.
And I'm sorry, Your Honor, the follow-up date in August was what?
August 13th.
13th.
And we'll readdress it again on Thursday.
All right, sir.
Mr. Crawford's not available on Thursday, then we're going to reset it to August 13th.
Thank you.
Mr. Brewer is in the hallway with Mr. Hawkins. So he is here, Bryce Brewer. James Godwin.
Here.
Ricky Serta. Dallas Hightower. Daryl Smith. Mr. Schmidt, will you approach on that? Hernandez. Justin Lee Dupree, CR 23-210, 211, and 212. Mr. Dupree is represented by Mr. Weiner. Mr. Weiner filed a motion for continuance that was granted by the court. Docket call has been continued until August 1st. Richard Homer. Jamie Taylor Warren, CR 24-120, set for arraignment today. Mr. White filed a waiver of arraignment. Court has approved that, and pretrial has been set August 15th. All right, is there anyone else that's in the courtroom and your name's not being called? All right, do we have any attorneys that are ready? Mr. Bingham, are you ready, sir?
Yes, sir.
Jennifer Rollins?
Judge, can we approach on that real quick?
Yes. All right, this is State of Texas versus Jennifer Danielle Rollins, CR 22-226. Ms. Rollins is here today on a motion to revoke. The court understands that the state defense needs additional time to negotiate the case. Court's going to reset Ms. Rollins for the evidentiary contested docket on August 27th at 9 a.m. And once Ms. Rollins gets her notice of appearance, she's free to go.
We provided that to her. She has it, the yellow form.
Yeah, yellow phone. You're
Yep.
free to go. Thomas Norman.
Judge, Mr. Norman has the revocation of probation here. He has one in Kaufman, a new case in Raines, and two cases in Smith County that are unfiled and unindicted. We're in the process of talking to the prosecutor in Raines County and Kaufman County, trying to get everything resolved at one time. So when he goes into custody, if he does, it's all coordinating. In talking to Ms. Curry, we're hoping to kind of, Raines County has filed their case in the new case. Kaufman, I've not been able to get a hold of the prosecutor there, but I anticipate if anything occurred, maybe it would be in custody in one of the other counties who would go off bond here and be working that credit but in another jail, if that's what occurs. So we're just asking to move this case. So I have time to coordinate everything where he can go in, handle them all at one time.
You know about how long you're looking for?
We had asked to reset that one the same date. I'll be here August 27th. He's on bond here. He's not had any violations on the case here, and just reset it to August 27th. And if we get it resolved quicker, we'll let the court know if that's okay.
Any objection from the state?
No objection, Your Honor.
All right, there being no objection, the motion to revoke is reset to August 27th.
Thank you. And I'll provide him the notice here.
All right, Mr. Norman, you're free to go.
We'll be in touch with you.
Crystal Getz, CR 2484, CR 2485, set for pretrial. Go ahead, Mr. Bain.
Thank you, Judge. I talked to Ms. Curry yesterday on this one. We're providing her with some counseling records on the alleged victim. She's attempting to get body cam videos from the officers that we don't have, and I don't believe they have either. The state's been very good about getting us what they have, but we think that there's still body cam videos out there. We're going to provide them records. There may be some phone calls from the jail that Ms. Curry's attempting to get for us. We've talked about this case a couple times on the phone, and we were just asking to reset it, be able to get those items of discovery.
Any objection from the state?
No objection. And we had the same August 27th date, just
I typically don't like to put those on a contested docket, but I'll do it for you, Mr. Bain.
I appreciate it, Judge. Thank you.
Court sets Ms. Getz for pretrial August 27th.
And I believe there's two cases, the 00084 and
85.
85.
Yes, both cases set for pretrial August 27th.
And I'll provide there's evidence. So, Judge, that's all I have. I appreciate the court's help.
Thank you, Mr. Bingham. Good to see you.
All right, good to see you.
$140 and $140.
Mr. Burr, come on up. This is cause number CR 24-00003, State of Texas versus Bryce Andrew Brewer. Mr. Brewer, sir, if you'll raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your name is Bryce Andrew Brewer, correct?
Yes, sir. All right, go ahead now. Sorry.
So your name is Bryce Andrew Brewer, is that correct?
Yes, sir.
And Mr. Brewer, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Mr. Brewer, have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Matt Hawkins. Are you pleased with Mr. Hawkins and the work he's done for you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and that you've had all of your legal questions answered?
Yes, sir.
Do you understand everything that you read and signed that's part of your plea agreement here today?
Yes, sir.
Mr. Hawkins, do you believe Mr. Brewer to be competent?
I do, Your Honor.
And have you explained to him his rights as they pertain to this case?
I have, Your Honor.
Do you believe that he is entering into this plea agreement intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Brewer, you are charged by indictment with a third-degree felony offense of theft of property greater than $30,000, less than $150,000. The range of punishment for a third-degree felony is not less than 2 years in prison or more than 10 years in prison, and you could also be fined up to a maximum $10,000. I see that there is a plea agreement in your case wherein upon your plea of guilty to that offense, the state's recommending to the court that the court not convict you today, rather, but place you on community supervision for a period of 10 years, ordering you also to pay restitution in the amount of $59,699.94. That's being payable to the Grants Lane Independent School District for the restitution in this case to be paid joint and several with your co-defendants in this case. Those co-defendants being Christian Berkwin, Hudson Griffin, Daytona Blue, and Trevor Blackman. In addition, you'd be responsible for court costs of $290 and reimbursement fees of $90. And the state, as part of the agreement, is also dismissing an unauthorized use of a vehicle case that's not been indicted. Mr. Brewer, is that your understanding of the plea agreement?
Yes, sir.
Mr. Hawkins, have you also explained to Mr. Brewer the advantages and disadvantages of a deferred adjudication plea?
I have, Your Honor.
All right, Mr. Brewer, understanding the plea agreement, understanding the range of punishment, how do you plead to theft of property greater than $30,000, less than $150,000?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Hawkins, any objection to the stipulation of evidence?
No objections, Your Honor.
Stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the school district is supportive of the plea.
Thank you, Mr. Hartwell. Anything further from the defense?
No, Your Honor.
All right, court's reviewing the stipulation of evidence. All right, based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Brewer of this offense. The court will follow the plea agreement and recommendation of the state today. The court defers a finding of guilt, does not convict Mr. Brewer of this offense. However, the court does place him on 10 years community supervision, orders him to pay restitution as a condition of community supervision in the amount of $59,699.94 to be paid joint and several with the co-defendants in cause numbers CR 24-2, CR 23-216, CR 23-200, and CR 23-201. In addition, the court is dismissing under section 1245 unfiled, unauthorized use of a vehicle in DA 2023-672. The court also assesses court costs in the amount of $290 and reimbursement fees in the amount of $90. All right, Mr. Brewer, did you graduate from Grants Lane ISD?
No, sir.
Have you graduated high school?
No, sir. I went to Kaufman High School though, and doing my
You're gonna speak up because
I'm doing my GED courses right now. I'm studying all those and,
Have you ever been a student at Grants Lane?
no, sir.
You said you've always gone to Coffee.
Yes, sir.
Well, Grants Lane ISD is giving you a great opportunity here. One that Mr. Hawkins has helped secure with the consent of the DA's office. So what I'm trying to tell you is that between the school district, the prosecution, and your defense, they've all put you on a path to where you can put this behind you and it not result in you becoming a convicted felon for the rest of your life. Do you understand how important, what kind of opportunity you're seizing here today?
Yes, sir.
You understand that that opportunity is also one for you to spoil.
Yes, sir.
You understand that the opportunity is nothing more than an opportunity, meaning that it's not been given to you yet, meaning that the case has not been dismissed. You're not free to go. You understand that? So it's within you have the opportunity to be successful, and it's within your capability of doing that. But you understand that you're going to have to work hard to make sure that you comply with every condition of this community supervision, meaning that you're going to have to pay, if none of your co-defendants pay a single dime, let's say that none of them pay a red penny
Yeah, I
to
gotta pay it all.
this, you got to pay the whole thing. If you don't, then you can come back for a hearing. Court could do a multitude of things. Court finds that you violated any conditions. I could revoke your community supervision. I could make you a convicted felon, and I could sentence you anywhere from 2 years to 10 years in prison.
Yes, sir.
It's pretty serious. How old are you?
20.
20. You're 20 years old. It's pretty young in life to be dealing with such serious criminal activity. You understand?
Yes, sir.
You agree?
Yes, sir.
Are you working? Do you have a job?
Yes, sir.
Okay, and so what's your plan to pay off the restitution?
Well, I'm gonna slowly pay it off because I can't pay it off all at once. I got a kid right now and that's expensive too, so. Probably gonna try and do the 500 a month every month that I can. Try not to get behind. I'll do what I can.
All right. Do you have people that are supporting you?
Oh, yes, sir, a little bit.
You got family members that are supporting you?
Yes, sir.
All right. All right. So Mr. Brewer, my advice to you is to keep your head down, keep focused on what the goal is. And the goal is to comply with every condition of this community supervision to make your probation officer love seeing you when you walk in because you're not a problem. All right. Go to work, come home. You said you have a kid,
Yes, sir.
boy or girl?
Girl.
Girl. So go home, be a dad to her. All right. And then get up and go to work, finish your education or get a good job and do your on the job training. Be someone that family can be proud of, someone your daughter can be proud of.
Yes, sir.
Put this behind you, take this opportunity for what it is. Okay.
Sir.
All right. All right, Mr. Brewer, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, probation officer will be information. Mr. Hawkins, is that all you have today?
No, Your Honor, I have one more. It's James Wesley Godwin.
Mr. Godwin, come forward, please. This is cause numbers CR 23-140 and CR 23-141. State versus James Wesley Godwin. For docket call. Go ahead, Mr. Hawkins.
And Your Honor, we would ask for we'd ask for an additional docket call. Mr. Godwin's had some medical issues with his leg with his diagnosis that has really made it very difficult for he and I to communicate with what he's been going through. His surgery is scheduled for the 16th, this next week, for his for the removal and placement of his, I guess,
Tibia.
yeah, for his tibia. And so we would ask just if we can, Judge, just because of that, we could have another doc call down the road where give him time to recuperate a little bit.
Any objection from the state?
No, Your Honor.
All right, there being no objection, court will grant the request for continuance. We'll reset docket call. Rob, I'm gonna reset you to August 27th. Try to give you enough time to. It's 1, 2, 3, 4, 5, 6, that's 7 weeks. Try to give you time to
Thank you.
recover from your surgery, okay? August 27th at 9 a.m.
Judge, I appreciate that.
You're welcome, sir.
Sir.
Yes, you're excused. Thank you, Mr. Thomas. Good to see you.
Judge, I'm ready to go. Actually, I'm ready, but I think my client stepped out of the picture.
This is cause number CR 24-101, State of Texas versus Adriana Marie Jacobs. This, Jacobs, you have been indicted for the second-degree felony offense of burglary of a habitation that does carry a range of punishment of not less than 2 years or more than 20 years confinement in prison if you were to be convicted, and a possible fine not to exceed $10,000. Is it my understanding that you are wanting the court to grant you time to retain a private attorney?
Yes, sir.
How long do you need, Ms. Jacobs? If I give you 30 days, will that be sufficient?
Yes, sir.
All right, Ms. Jacobs, I'm going to reschedule you for Tuesday, August 13th. That will be at 9 a.m. Have you met with Mr. West yet, our pretrial
Yes.
release officer? So
Yes.
you've already signed your conditions of pretrial release? Okay.
Yes, sir.
All right, so Ms. Jacobs, I expect you to come back here with an attorney. If you're unable to hire the first attorney you talk to, that doesn't mean you quit talking to attorneys. You keep on calling them, you get someone to represent you. And I'll see you back August 13th. Make sure you stay in compliance with your pretrial release. All right, free to go.
Thank you.
Mr. Homer back.
Yes, sir, he is.
All right, Richard Kevin Homer, CR 24-74. Come on around, Mr. Homer. All right, Mr. Homer is set for pretrial today. Go ahead, Mr. White.
Your Honor, at this time, I don't anticipate needing any further pretrial. We'll abide by the court's standing order. We've got to get some records, and I explained this to Ms. Curry. So I can get some most recent counts and records and some other things from Mr. Homer. And kind of looking at my schedule as it's coming up through August. I'm going to ask the court, move this to docket call but I'm gonna request if the state has no objection, for a little bit longer period to make sure I get all that done and then have the opportunity to speak with Ms. Curry and, or Mr. Hartwell, about this situation a little bit more at length.
Any objection, state?
No objection, Your Honor.
What about Tuesday, September 3rd?
Your Honor, that'll work.
All right, court sets Mr. Homer for docket call September 3rd at 9 a.m. Once he gets his notice, it's free to go. Mr. White, can I see you before you leave?
Yes, sir.
I'm gonna step out there.
Mr. Serta.
Ricky Bryant, sir.
Yes,
All right, your name is Ricky Bryant, sir. Is that correct?
yes, sir.
And Mr. Serta, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
You feel like you've had enough time to talk with him about your case, that you've had all of your legal questions answered?
Yes, sir.
Is there anything about your paperwork that's part of your plea agreement, Mr. Serta, that you've read over and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Mr. Serta to be competent? And if so, have you explained to him his rights pertaining to this case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Serta, you are charged by indictment with a state jail felony offense of abandoning or endangering a child with is this criminal negligence? It says intentionally, knowingly, recklessly criminal negligence. What's the actual?
Criminal negligence. Your Honor.
Criminal negligence. That being a state jail felony, Mr. Serta, that does carry a range of punishment. If you were to be convicted and sentenced, the sentence would be within the range of not less than 6 months or more than 2 years confinement in a state jail prison. I see that the plea agreement in your case is that you would be pleading guilty to that offense in exchange for the state's recommendation that the court not convict you today, but rather place you on deferred community supervision for a period of 2 years, ordering a $300 fine, court costs of $290, and reimbursement fees of $590. Is that your understanding of the plea, Mr. Serta?
Yes, sir.
All right, understanding the range of punishment, understanding the plea agreement, Mr. Serta, how do you plead to abandoning or endangering a child with criminal negligence?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Mr. Serta, has anybody threatened, forced, or pressured you to plead guilty to this crime?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objections to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Is the victim or victim's family supportive of the plea?
Yes, Your Honor. And I guess additional support for that would be that, we've received reports that Mr. Serta has been, doing an excellent job with the CPS case and doing everything that he's been asked to in that, regard.
Thank you, Mr. Earl. Anything further from the defense, Mr. Schmidt?
No, sir.
All right, court's going to review the stipulation of evidence. All right, the court having reviewed the evidence finds sufficient evidence to convict the defendant of this offense. The court will follow the recommendation of the state and the plea agreement. The court hereby defers a finding of guilt on the charge of abandoning or endangering a child with criminal negligence, a state jail felony. Court places Mr. Serta on 2 years community supervision, orders him to pay a $300 fine, $290 court costs, and $590 in reimbursement fees. All right, Mr. Serta, you're hereby remanded to the custody of the probation department. Terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with Deputy Martinez. Put that in report to the probation officers and they'll give you more information. Schmidt, who's next?
Dallas Hightower.
Dallas Justin Hightower, CR 23-217. All right, Mr. Hightower is set on his motion to revoke today.
That's correct, Judge. We're not ready to proceed. Need some time to talk to the state. Ask it be reset to either a regular docket. I think in this particular case, we might have some additional discovery we need to seek on the motion.
All right, any objections from state?
No, Your Honor.
All right, then the court will set Mr. Hightower. I'm gonna go ahead and set him for two settings, Mr. Schmidt. I'm gonna go ahead and set him for August 13th. And then if we're not resolved on the 13th, I'm gonna set him for the contested hearing on the 27th.
Do you understand that? So we got 2 dates on it, 13th and 27th. If we get resolved here, that day goes away. If not, then we come back to date. Okay. Yes. No. No. Yeah, so. Gary and Dotson.
Dodson. This is cause number CR 24-97, State versus Darian Dwayne Dotson for arraignment. Court finds that Mr. Dotson has requested court-appointed counsel. Court reviewing his application finds him to be indigent, has appointed the Honorable Richard Schmidt to represent Mr. Dotson. We're set for arraignment today. Mr. Schmidt, have you had an opportunity to review the indictment?
Yes, sir.
Go ahead.
Judge, we have reviewed the indictment. His name is laid out correctly, understands the charge. We waive reading, enter a plea of not guilty and ask for a pretrial setting.
All right, court finding that Mr. Dotson waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets Mr. Dotson for pretrial hearing. You want that August 13th date, Mr. Schmidt?
Oh, that'd be fine, Judge.
All right, court sets Mr. Dotson for pretrial August 13th at 9 a.m. And Mr. Dotson, have you met with the pretrial release officer, Mr. West, yet?
Yes, sir.
Yeah, so you have your conditions.
Yes,
All right, once you sign your notice, you're free to go.
Yes, sir.
So, okay, so it's okay. That's it. This will be your only notice, I don't lose it, okay? Yeah, but. But my email again here, so you know, right? That's not good, see you later.
Good.
Yep, you're good, take care. Nathaniel Potter.
Nathaniel Warren Clay Potter, CR 24-107. All right, the court finds that Mr. Potter requesting court appointed counsel. The court, upon reviewing the application, finds him to be indigent at this time. I have appointed the Honorable Richard Schmidt to represent Mr. Potter. We're set for arraignment today. If you've reviewed the indictment, go ahead, Mr. Schmidt.
Yes, sir, we've reviewed the indictment, his name is spelled correctly, understands the charges, will waive reading, enter a plea of not guilty, ask for a plea trial.
All right, court finding that Mr. Potter waiving the formal requirements of arraignment, enters his plea of not guilty into the record, sets this matter for pretrial on August 13th. a.m. And Mr. Potter, have you also signed the conditions of pretrial release with Mr. West?
Yes, Your Honor.
All right, you're free to go.
All right, talk to you soon. Mr. Holdren. With their.
Need time to speak with Mr. Olson?
Yeah, a couple minutes.
Yes, sir, no problem. CR 24-100, State versus Andrew Wayne Holden for arraignment. Court finds that Mr. Holden requesting court appointed counsel finds him to be indigent at this time. Court has appointed the Honorable Richard Schmidt as counsel for Mr. Holden. Mr. Schmidt, have you had an opportunity to go over the indictment, Mr. Holden?
Yes, sir.
Go ahead.
Judge, his name is correct. Understands the charge of waive formal reading and or plead not guilty as per pretrial.
All right, court finds that Mr. Holden waiving the formal requirements of arraignment. Court enters his plea of not guilty into the record. Court sets this matter for pretrial. You believe that August 13th date is sufficient, Mr. Schmidt?
I think so.
All right, court sets Mr. Holden for pretrial August 13th at 9 a.m. Wes, I think you've already met with him, correct? All right, so the court notes that Mr. Holden has met with the pretrial release officer, has his condition. The only other issue I need Mr. Holden to address, Mr. Schmidt, is that I need him to go out to the Van Zandt County Justice Center and supply his fingerprints. I believe he was possibly arrested out of the county. Either way, we do not have a TRN tracking number from the state for Mr. Holden, so I've signed a TRN processing order. So Mr. Holden,
Yeah, go in, print you in the leash. Okay.
Mr. Holden,
Take that.
he'll just, as soon as you leave court, just go out to the jail and show them that order right there. They're gonna take you back. They're just gonna take your fingerprints on some glass electronically. They won't change you out or hold you. They may not get to you immediately, but just be patient with them, but they're not gonna change you out, put you in a cell or anything of that nature. They're just gonna take your fingerprints so they can report that to the state, okay?
Yes, sir.
All right, we'll see you back on August 13th.
Good. Yeah, they want to see that. All right. Good. Take care.
Do you have any further cases, Mr. Schmidt?
I don't think so. Right. Daryl Smith, but.
Yes, so the court has signed an order transferring cause numbers CR 24, 111, 112, and 113 to the County Court of Law for Daryl Wayne Smith II. Court's not going to issue a judgment nisi at this time. I'm going to allow the County Court of Law to send out a notice of hearing for Mr. Smith and give him an opportunity to appear down in that court.
Thank you.
All right, the court has completed this morning docket. There's one defendant who has not appeared. Her name is Sky Brianne Cooper. Ms. Cooper has called in indicating that she's had car issues. Do you have any update on that, Ms. Abraham? All right, Ms. Abraham has attempted to reach back out to Ms. Cooper with no response. So this time I'm going to have Deputy Martinez call Ms. Cooper's name loudly, distinctly 3 times in the courthouse. The court is going to allow Ms. Cooper to make an appearance today, either before noon or during the jail docket in the courthouse. If that occurs, then I'll notify the state of her presence. If she does not appear, then the court will be issuing alias capias judgment. The court is going to take that under advisement until. All right, the court finds that Sky Brianne Cooper has not appeared as ordered. The court has called her name loudly, distinctly 3 times in the courthouse with no response. The court also finds that Ms. Cooper having contacted the court indicating that she's unable to be here. The court is going to allow her until 5 p.m. today to make an appearance before the court makes any judgment on her bond. So the nisi alias capias will be under advisement until 5 p.m. All right, court is going to stand in recess until 1:30, which will start the afternoon criminal docket at the gym.